First, I'd like to welcome our moderator, Shawani Johnson, who is a third-year student at the University of Oregon School of Law and a Wayne Morse Law Fellow. She came to Oregon Law interested in data privacy and cybersecurity and founded the Technology and Law Club in her second year. After graduating law school, Shawani hopes to continue to pursue these interests within the legal profession. Our featured guest speaker today is Senator Ron Wyden. He is a 1974 graduate of UL Law and has held the U.S. Senate seat once occupied by his mentor, Wayne Morse, since 1996. Senator Wyden has been a champion for net neutrality, internet freedom, and cybersecurity for decades. He is a leading voice on policy related to tech companies and data privacy, and co-authored the Communications Decency Act, which governs everyday interactions with websites, services, and social media networks, and impacts fundamental rights under the US Constitution. Senator Wyden is also chair of the Senate Finance Committee and a senior member of the Energy and Natural Resources Committee. He also sits on the committees on budget and intelligence. He served in the US House of Representatives for 15 years. While there, he played an influential role in the passage of Section 230 of the Communications Decency Act of 1996. He has won many awards for his pioneering role in establishing a free and open internet and is known for his commitment to ensuring that more Americans can afford access and have means of access to broadband and phone service. Senator Wyden currently sits on the advisory board of the Wayne Morse Center for Law and Politics. Shawani, I am delighted to hand things off to you.
Thank you, Dan.
US Senate, it's being yielded to you, Ms. Johnson.
Thank you, Senator Wyden. Thank you, everybody, for attending today's event. So the title of today's event is Fundamental Rights, Data Privacy, and the Power of Tech Companies. When most people think about fundamental rights, they probably think about an old piece of paper inscribed with thick black ink hanging in an old building somewhere. But today, in 2021, our engagement with our fundamental rights and the First and Fourth Amendments in particular, as we'll see today, is not just with some old piece of paper. Instead, we engage with these fundamental rights as soon as we reach into our pockets and pull out our cell phones, or sit down at our desks and log on to a social media platform. Our phones, our computers, and our online presence implicate our rights every day. So we must ask ourselves about the relationships that implicate these rights. We have to ask about the relationships between tech companies, the government, and the American people. We have to ask ourselves where the power lies. I think a good place to start talking about this is the Fourth Amendment. Senator Wyden, the Fourth Amendment, as you know, gives people the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So what does this mean for our data? That is the information generated when we use our phones or the internet. Specifically, Senator Wyden, what do you think the relationship between data privacy and the Fourth Amendment is?
Well, I'll begin by saying I'm a member of the Ben Franklin caucus, and I sort of founded it. And Ben Franklin famously said that anyone who gives up their liberty to have security really doesn't deserve much of either. And I think that highlights the tension between the Fourth Amendment, which ensures protection of people's privacy, and the legitimate concerns that we all have with respect to safety. And to some extent, the way I would sum it up, Ms. Johnson, is since we want both, since we want a balance on something that some scholars have called the constitutional teeter-totter, if you have smart policies, you can get both. Weak policies, you will get less of both. And I'm sure we'll talk about it over the course of the discussion. But my leading the fight for strong encryption rules is an example of policies where we'll be safer and our liberties will be more protected.
So piggybacking off that a little bit, if we're talking about the tension between our liberties and our privacy interests, we can think about the power of tech companies and how a lot of this tension is generated because tech companies have our data. Do you think, and still talking about the Fourth Amendment, that personal data should be held by tech companies and be able to be accessed by law enforcement?
Well, I'm actually introducing a bill this week called the Fourth Amendment is not for sale, because we have seen these data brokers and sleazy operators basically doing an end run on government. But here's, I think, the point, and this might be worth talking about. I'm going to walk through it. A lot of big companies now have a business model where they give consumers a lot of free services in exchange for their getting to track what those consumers are doing, where they go, who they talk to, things of this nature. And that data can then be directly mined by the company that collected it. Or, as my bill's going to deal with, right now, it can be sold to other firms by data brokers. So it's been a trade-off. The consumer can enjoy countless, apps and get all this, free stuff, but it means that companies are now storing far more data about consumers, in my view, than is really, necessary. And it means that the information of Oregonians and Americans, anybody who's got a credit card, their information can be made widely available. That's what I'm going to be checking to, that's what I seek to check with my legislation I'll introduce next week. The Fourth Amendment is not for sale.
So, talking about the Fourth Amendment not being for sale, and this information that is already gathered from American citizens by tech companies, information that can be used to aid in law enforcement. For example, location data of people who have committed crimes. We've had a lot of examples this year even of law enforcement using data or social media information to be able to find people, to track people. What do you think then about this middleman relationship between tech companies and the government?
Well, the reason I'm going to have bipartisan support for my legislation is that I don't think my colleagues in the Senate think that this is a partisan issue. I think they believe, like I do, that there ought to be protections for Americans' data from shady data brokers. And there should be protections so that the government, and my concern is all kinds of other people, are going around the courts and buying the data of people who are following this discussion, who, let me point out, legally handed it over to all these companies who said, oh, I'll give you free services, and oh, I'll give you all these apps, and I'll give you all this stuff. Everybody said, hey, sounds pretty cool. And nobody really thought through the downside, which is now all this data is available to companies, and they pretty much, until my law passes, have kind of free hand in terms of giving your data out for money.
So I've thought a lot about this as a law student. It's come up in a couple of my classes, criminal investigation, it's come up in IP, this idea that in order to access technology, use your cell phone, use an app, you without thinking, click agree for terms and conditions, or you agree to a privacy policy without really reading what's on it, because you have to use your phone to engage in society today. But what this means, to your point, Senator, is information is just given away, and it's done so with, I think, a lack of complete understanding from the average citizen about how we're engaging with our cell phones, our websites. What do you think we can do besides your legislation to hold tech companies accountable or provide information to the average citizen about what's being done with their data?
Well, I think in addition to my law, which says that the government should be getting a warrant, except in what you legal scholars know to be exigent circumstances. If there is some prospect that people are going to be killed or something, under all of my privacy legislation, there is in effect a public safety exception where the government can then get the information and then afterwards come back and settle up and demonstrate that they actually had a need. So the law providing more tools is critical, because I think if you don't have a requirement that there needs to be a warrant except in these exigent circumstances, you don't have anything to build on. But I do think there should be a massive consumer education discussion, which is why your program is so good. And I see my O right down there. I won't do my demonstration as a Duck alum, but it may well be that lots of people say, I'd rather have the free stuff. I'd rather have the apps. It's a free country, and everybody has a constitutional right to make judgments that are what they think are in their best interest. I do think more people will say we're striking the right balance in our Fourth Amendment is not for sale bill, because we want to know about what's going to be done with our data. We want to make sure that it's not just sold without protections that the warrant requires, and that's what our bill does.
So the idea of searching a cell phone or searching computer records, like you said, and like your legislation proposes, requiring a warrant, except in the exceptions that already exist for warrantless searches and seizures of property, exigent circumstances, like you said, in some cases, searches incident to arrest, things like that. The scope of that search is limited by restrictions on the Fourth Amendment. The scope of the seizure is limited by restrictions on the Fourth Amendment. Can you talk a little bit more about the exigent circumstances or other exceptions to the warrant requirement?
Well, it's really a national security exception, for me. If law enforcement, intelligence officials, and I'm on the intelligence committee. I'm not going to get into classified matters here, but as a general proposition, if intelligence officials and law enforcement officials have a reasonable basis to believe that imminent harm, the words can vary, imminent harm and loss of life is reasonably likely to be suffered unless action is taken. That's what constitutes the exception. I've never had anyone challenge the grounds here, because I think while you lawyers are going to have kind of some discussions here, it's got to be imminent and it's got to be real. You don't just get to go on a fishing expedition and then say, hey, you know, I thought something might happen.
The idea that the purpose behind the Fourth Amendment, I think, is to have some limitation to limit the government's ability. And if, like you said, if you can just go on a fishing expedition, I think that undermines the purpose of the Fourth Amendment a little bit. I think
I think you said it very well. If the Fourth Amendment is not subject to vigorous checks on the government's surveillance power, that's not keeping with the Ben Franklin spirit.
So you talked a little bit about national security interests, but I think that opens up a broader conversation about what the United States is doing with respect to privacy, the legislation you proposed, and what some other countries are doing. The European Union has the GDPR. Other countries think about privacy a little bit differently, but we are really limited to the Constitution, and everything kind of flows from there. So I think I want to change track a little bit and talk about the other ways that privacy is implicated, data privacy is implicated because of the Constitution, and versus how other countries deal with it, specifically the First Amendment. Mr. Tishner talked about this at the top, but you co-authored the Communications Decency Act, Section 230 specifically. Section 230 has been called the 26 words that created the internet. I'm sure you know that. But with respect to 230 and privacy, can you talk a little bit about the history behind the Communications Decency Act?
So here it is. In 1996, and really 1994 and 1995, I became Oregon's first new United States Senator in essentially 3 decades. And we, of course, had always been, as a state, about forest products. And I said, if I get elected to the Senate, I will fight like hell for those rural communities and their mills, and trying to make sure that they had an economic livelihood in a sustainable way. And I want to get Oregon into some new areas. So we had more opportunities, economic opportunities for our people. And I show up in the Senate, and nobody knows how to use a computer except for one fellow, Senator Leahy of Vermont. And at that time, the talk show hosts were having a field day with the Senate because the chairman of the committee had been asked what the internet was. And he said, you know, it's just a series of tubes. What's everybody fussing about? And the whole country said, oh my God, the Senate's top technology person thinks that the internet's a series of tubes. And the talk show hosts were just howling. So I said, I'm going to get into these issues. And I already in the House had started to get interested in this. And the way 230 came about is I said, I know what I don't know. This is all brand new. It's still the case. I don't know much about a lot of things, but I'm a journalist kid. And so I like to go out and just ask a lot of questions and try to kind of figure out what's going on. And around that time, some jurisdictions were saying that if you invested in a blog or a website, all this new stuff, you could be held personally liable, either as an owner or investor, this kind of thing, for what was printed on the blog or platform website. And I'm scratching my head and I'm saying, I don't know everything about this, but I bet you this internet is going to have a lot of postings. Why in the world would anybody give 5 cents to the owner of a blog if they were going to be held personally liable for everything that couldn't possibly be controlled? So I got together with a very conservative Republican, Chris Cox, a terrific man. And he and I talked about this. We said, this is not about being liberal or conservative. It's about being smart about technology policy. So we wrote a law that ensured that the person who posts the content is liable for the content. And the platform has some protection against people who have frivolous lawsuits and all that kind of thing. And then we said, we'll have another provision that gives the platform the ability to moderate what's posted on the sites. We all hate all this filth and slime and racism and all the rest. So now people write articles. Ron Wyden and Chris Cox created $2 trillion worth of wealth for America. We wouldn't have all these platforms, we wouldn't have all this commerce, we didn't have any of it because of this. Prompting my wife, who owns one of the great bookstores in America, The Strand, she said, I read that you created $2 trillion worth of wealth. I never saw any of it. And so even in my own household, people are asking questions. But let me bring it home in a very specific way. I'm absolutely convinced that if Section 230 had not come into being, the Me Too movement and Black Lives Matter would be censored out of exposure on a lot of platforms and the like, because those people would never have wanted to take on the powerful people, like Me Too movement, all those networks and all the rest. So for me, Ms. Johnson, it's always been about giving a voice to the little guy. I know that everybody says, oh, this is a big gift to big tech. Big tech can take care of themselves. They don't care about, what I'm doing. They can take care of themselves. They got so many lawyers and law firms and lobbyists and all this. But our concern at the beginning was a little person with an idea who was online, who could be crushed by a big guy. And it is still true. I'll give you an example. Everybody says, oh, 230 is for big tech. You may have heard about the SESTA-FOSTA bill, which was supposed to stop sex trafficking. And I was one of two who opposed it, because I said the only thing you're going to do is drive these horrible people, these traffickers, to the dark web, where you won't be able to get them with a search engine. And A, we were right, because that's exactly what's happened. But B, at the end, Facebook and others that had said, oh, we're such big fans of technology and 230, they sold everybody out, because when they were small, they saw why you needed it. And when they got big, they just said, we'll draw up the bridge. We'll draw up the drawbridge. And who cares about those little people? We'll just monetize anything we got to do. And, we got ours, and who cares about them? So it was about the little guy at the beginning, still is. That was a longer answer than you wanted, probably.
So I think you bring up a couple of really good points, and I'll say the ability to be on social media or connect with people that I wouldn't otherwise be able to connect with. For example, I am very obviously a woman of color in Oregon, and I'm interested in the privacy space. And that field is still really growing in Oregon. So being able to go on Twitter and connect with people or have ideas or see other people's ideas has really allowed me to be in this space in ways that I wouldn't have without the internet being what it is today. But it has negative implications, to your point about sex trafficking and things like that. And I think that people have valid concerns about what Section 230 has meant for certain areas of the law, the power of tech companies. So I was wondering if you could speak to thoughts on reform of 230. Do you believe that it's necessary? Do you think that there's a cost or benefit to reform? Everybody has really been talking about this law a lot lately, and I'm just wondering what your thoughts on that are.
First of all, just because you write a law doesn't mean it's perfect. So I'm always open to changes. I have a two-part test. One, that any changes not stomp all over the First Amendment. And second, that they not harm the ability to moderate, because you get rid of 230 and you actually have the ability to get rid of some of this horrible stuff. Now, let me give you an example of some of the big challenges as we get into this, because your terrific question, great one to talk about. So there is an enormous amount of misinformation about 230. And when somebody told Donald Trump that there was something called 230, he went, oh, this is great. I think Donald Trump, will try to bully Twitter into printing my lies about vote by mail, which we care about very deeply in Oregon. And of course, he wasn't able to do it, but wasn't for a lack of effort. And I will tell people following the discussion, I don't think Donald Trump would know 230 if it hit him in the head. And I think he probably thinks 230 is the middle of the afternoon when everybody goes out and takes a break. I don't think he knows the first thing about it. And here's what we're up against. Even the most knowledgeable people in America have had trouble getting their arms around this issue. And I'll give you an example. After the law passed, sometime after it passed, the New York Times wrote a huge article about Section 230. Big picture of Chris Cox and me and a bunch of young guys who allegedly knew something about the internet. And the caption underneath our picture said, Congressman Cox, by then I was in the Senate, Senator Wyden, are the authors of the law that gave the green light to hate speech in America. And I said, I looked at it and I just, my eyes, just popped out of my head. I said, you gotta be kidding me. And we called up the New York Times and we said, folks, you're one of the most respected news outlets in America. Did you know that the First Amendment basically ensures that about 95% of all speech in America is protected? So if Chris Cox and I get run over by a bus and 230 disappears, the internet looks just like it does today, because 95% of all speech in America is protected by the First Amendment. So the New York Times 2 days later actually printed a correction that said, I don't have it in front of me, but we can get it to you. Hate speech is not protected by Section 230. Hate speech is protected by the First Amendment. So we got a big job apropos of this reform effort to start educating people on what it's about.
So I think you bring up a really interesting point about this relationship between free speech and the First Amendment and Section 230. Being able to say things online on Twitter, for example, allows people to engage in the public discourse that the First Amendment intended, to be able to talk about more than just our day, but to share news, to learn from each other, to talk about the government, to critique the government. But to your point, this ability to engage in public discourse allows negative speech at times. So efforts, I think for some, efforts to reform Section 230 has this intent behind it, to limit the negative consequences of engaging public discourse. For example, where you mentioned Me Too and Black Lives Matter at the outset. Being able to talk about Black Lives Matter and Me Too and connect with each other is wonderful. For me, it's been wonderfully beneficial, especially being a woman of color in Oregon. But then it invites hate speech at times. Can you talk a little bit more about
the important line of demarcation here is Section 230 makes it clear that there is no immunity for breaking the law. Okay, so people say, oh, everybody gets off free. No immunity whatsoever with respect to breaking the law. I'm now looking, there's a lot of stuff online that almost encourages violations of civil rights law. I'm very serious about civil rights. It's a bedrock value for me. I'm trying to figure out now, maybe you law students can figure it out. Is the issue that the Trump administration would not enforce the civil rights laws? Or is it an issue that this is a gap in 230? And because we had to spend most of our time in this rearguard action, trying to, every time Donald Trump, said something absurd about Section 230, trying to, correct it, we're still exploring it. But I obviously feel very strongly about protecting civil rights law in America. And I'll point out, and we can make it available to students, 70 civil rights groups signed a letter to the Congress. Be very cautious about unraveling Section 230 because of the protections I'm talking
about. Thank you, Senator. We have a bunch of questions from the audience. There's a lot here. Do you mind if we take some questions from the audience?
Sure, a few. I'm kind of juggling right now. It's been nonstop. About 70% of the recovery plan went to the Finance Committee, where you noted I'm chairman of the Finance Committee. So it's Friday, but it's gonna be a long night. But let's take a few, sure.
Okay. Let's see. Okay. This is a really good one, very topical, like you were talking about the recovery plan. How do you balance data protection and privacy versus public interest related to COVID exposure? So we have contact tracing that's been going on, trying to make sure that we're mapping COVID exposure, but this also presents data privacy concerns.
Well, there are a lot of privacy issues and speech issues associated with it. As you know, there's been an immense amount of targeting of Asian Americans in the last few months, with people hurling these charges. You're responsible for the China virus and the like. And we're now working on the floor of the United States Senate right now to pass hate crimes legislation, to strengthen what we're doing, primarily to ensure that there's a point person in the Justice Department to ensure that we carry out prosecutions and the like. Now, in other areas, this is probably going to come up in the context of what now is been termed, perhaps there's a better term for it on campus, but if you heard the discussion about the vaccine passport, where people would basically have something, I've been vaccinated, off they go. I'm very concerned about the privacy rights associated with it. Now, I haven't had a chance to study it, but you know what I try to do, I was home for 2 weeks and I had a lot of long car rides and stuff as I get around for town meetings. I have wondered, is there a way to deal with this where it becomes something like an optional fast lane? In other words, if somebody wants to use it, they could, and there may be a reason why they would, but nobody is discriminated against. There are a lot of issues. I'm going to be very cautious about dealing with these kinds of questions because this is probably the most instructive kind of point. We know that a lot of these issues are very emotional, and that's when you write really bad laws with respect to ensuring that security and liberty, that's how I often put it on the floor. Security and liberty aren't mutually exclusive. We can have both with smart policies. We'll get less of both with not so smart policies. And apropos of, you know, COVID, it's raised a lot of issues, whether it's discrimination against, you know, Asian Americans who somehow, you know, people hurl these charges at them when they're on the bus or something. You're responsible for the COVID virus. And things of this nature. And people have said, people have come up to them in the grocery store and said, you're responsible for the, you know, COVID virus. And they said, what are you talking about? I'm just here to the grocery store trying to buy some apples for my kids. What's this about? And then the vaccine passport is going to be representative of this. I would come into that with considerable caution. And, you know, already when I read it, I said, well, I wonder if there's a way that you can find that's fair to all concerned that might be an optional kind of arrangement.
I want to also ask about, and this is another audience question. Do you think that recent changes to the Supreme Court, we have newer Supreme Court justices, could result in stronger privacy rulings concerning data tech and the Fourth Amendment?
I'm not convinced that that's the case. I mean, let's face it. Do you think that a woman's right to choose is a privacy issue? I certainly do. This court is not going to be very friendly or hospitable to a woman's right to choose. So we don't know where this court is headed, but let's make no mistake about it. Donald Trump had a litmus test, a far-right litmus test on issues like I just described, and I don't think it bodes well for a lot of the core values of Oregonians. By the way, we have some very, very conservative communities in our state. I was the first member of the Senate to come out for marriage equality. And when the press asked me about it, they said, you know, are you worried you're going to get defeated and all the rest? And shortly after I said, I'm just going to tell you what's in my heart. And they said, well, what's that? And I offered one sentence, and I have never uttered another sentence on the subject, substantive sentence beyond it. And I said, if you don't like gay marriage, don't get one. That's it.
I have another audience question. This is pertains a little bit more to Section 230, perhaps even the First Amendment. So there is something known as the right to be forgotten or the right to be deleted. And this audience member is asking, do you think that there should be a law for the right to be forgotten? Should there be a requirement that a company allow my information to be deleted?
You mean a law that a company should carry out your wishes?
So I think that there is.
Let me, because it's a great question. Any company that doesn't carry out a consumer's wishes isn't going to be in business very long. So tell the student I'd be interested in hearing more about it, but I'm interested in empowering consumers. And from the seat of my pants, apropos of this fact pattern, and remember, you guys are going to be real lawyers. I wasn't a real lawyer. I ran the legal aid program for the elderly and the Great Panthers. I remember the Iowa Bar Association. You guys are all going to go off and have great legal careers. But any company that doesn't carry out consumers' wishes, somebody walks in and says, "I want my information deleted," they're going to be a company very long. And apropos of this, are you being muted, Ms. Johnson? I thought you said need something.
Oh no, I was.
Oh, there you are. Great. This, whole question. Also, and I want to mention this before time runs out, involves a little bit of new accountability, because, for example, Facebook is arguably one of the 2 or 3 biggest players on the social media scene. Well, the Federal Trade Commission fines them, and it's lunch money for Mark Zuckerberg. It's nothing. Well, in my big privacy bill, which I'm pushing very hard, along with my Algorithm Accountability Act, which is also about protection for the consumer, in my privacy bill, if Mark Zuckerberg signed documents giving false information, for example, about privacy issues to the Federal Trade Commission or an agency deals with it, Mark Zuckerberg can be held personally liable, including the prospect of jail time. You send that message, and you're going to have some new protections for consumers. It's a new day.
I think that you make a really good point about the choice being with the consumer, as far as what they want to keep private, and I think that's in line, like we talked about earlier, with the Fourth Amendment, the idea of the idea that an American citizen is free from government intrusion into their personal effects, their house, their paper, etc. So I think the idea that somebody can choose to have their information removed by engaging with an internet service provider such as Facebook, I think it really goes to your point. That I have so many questions here. I think let's finish with this one talking, and we talked a little bit about this with 230, and I think it goes to our last question a little bit. What about First Amendment rights and the ability of social media platforms like Facebook, like Twitter, to engage in censorship a little bit, to be able to remove people from the platform entirely? President Trump no longer has a Twitter account. Can you speak to that?
Yeah. The Section 230 law basically tried to lay out rights and responsibilities, okay? I've already been talking about the rights, particularly of the person without power and clout. But let's talk about the responsibility. We put in a provision that gives the person who in effect owns the platform and website and the like, the ability to say that that was a racist posting that encourages hate and violence and the like, and to remove them from the site. Now, remember, these are private companies. Some people don't think that is appropriate either. They all just should be, public utilities and the like. And it's going to be a debate about all these things, but they're private companies. And Donald Trump, apropos of January 6th, he invited the domestic terrorists to come to Washington, went out on the Capitol steps and told them to fight. And look at what happened on January 6th. So yes, there have been people, who have said when you encourage conduct that we believe as the owners of this platform goes against these fundamental values, we're making that judgment. And some people feel too much is being moderated, and some people feel not enough is being moderated. And that's what Chris Cox and I thought was the real core of our law. And I thought it was going to be important law. I never thought it would be this visible and this important and the like. When I wrote it, I thought people are just going to think it's some kind of antifreeze that you're going to go to the gas station and you buy some 230 and put it in your car or something. But we made a core decision that the responsibility of the first part was on the individual, the person who posts the content, written the content, what have you. They're the one that is liable. And then because that provided some measure of protection, particularly the small websites, remember, we got people hosting and the like, they're really tiny, like in small Oregon towns. We want them to step up and try to show responsibility as well, to not have all this filth and hate and racism and misogyny and all this stuff online. So let me give you, can I have a lengthy closer, like 30 seconds? Thank you so much for what you're doing, Ms. Johnson. Wasn't a bad question or a comment in the House. I think those of you that are looking at technology in the law, you got a great opportunity. And I don't think I've told the story, but I think when I was a 3L, and I'd have to go check, there was actually a course called Computers and the Law at the U of O. I'd have to check, so I cannot back this up, but I'm pretty sure it was the case. And it was the driest and most boring kind of thing imaginable. And of course, computers then were like, 6 feet tall. I mean, nobody had a phone in their pocket. But you all are gonna get a degree, a JD, really soon. I think you got an incredible ride ahead of you. All the best, and let's put this in to be continued, okay?
Thank you so much, Senator Wyden. I really appreciate you taking the time to talk to me today. Thank you, everybody who attended. I appreciate all the audience questions. I know that you're incredibly busy, so thank you again, Senator Wyden. I really appreciate it.
Thanks, everybody.